Lyman to opine in terms of whether the actions of Mr. Rankin that were described in court were consistent or inconsistent with the various stages of the Portsmouth Police Department's use of force continuum. I also would have asked Mr. Lyman with respect to what's known as a 21-foot rule, and that what officers are taught with respect to how far a subject can travel within, or how long it takes a subject to travel within a 21-foot rule. I would have asked them about lunging distance in terms of national standards with respect to individuals being able to lunge 5 to 7 feet. I would have asked them that there is no tackling in police training, that hands-on to a subject can result in significant problems, an enhanced chance of getting a weapon. I would have asked him whether or not Mr. Rankin was required to use the OC spray that was on his belt, and he would have opined that he would not have been because it's on the same level or continuum as the taser, and that if it does not work, you move up and that you don't move laterally. And that would have been the extent of Mr. Lyman's testimony. Thank you.
Motion position.
Judge, the Commonwealth's position was that it was twofold. First, under 2:403, the testimony would have been confusing and misleading to the jury. Second, under 2:704, it would infringe on the jury's province by getting too close to the ultimate issues of reasonableness and self-defense.
It was my decision that I thought it would invade the promise of the jury with respect to the ultimate issue. And also, he had never qualified as an expert in the state of Virginia. Not required, but was not one an expert in the discussion of it. And I made one. Next issue.
Thank you, Your Honor. You're welcome. The next issue is as it relates to writings that were found in the backpack that was on Mr. Chapman's person at the time of this incident. Judge, we, understanding the court's ruling, just to put on the record, we intended to introduce evidence, specifically writings found in Mr. Chapman's backpack, to establish, pursuant to Rule 2:404, a pertinent character trait of Mr. Chapman, offered after evidence of self-defense is adduced. And those pertinent character traits, we would have argued, were related to anger and or rage. Judge, I would offer just photographs of two of the writings in the backpack that we would have moved to introduce had the backpack and its contents not been excluded. As I indicated, this was a backpack that was on Mr. Chapman's back at the time of the incident and ultimately found beside him after the shooting. These are photographs of the actual documents, and I would just ask that the court receive those for purposes of potential appeal.
And what was your position, Commonwealth? May
I first?
Yeah, as the Commonwealth argued. Yes, sir. Yeah, the Commonwealth made the argument that the defense waited 2 weeks prior to the date of the start of this trial to go to property and to go and view the evidence at the state police in this case, and that is where the contents of the book bag were reviewed by them for the first time. And Your Honor, the Commonwealth made the argument that all of the writings in the book bag, some of them had different dates. None of them appear to have the signature of the decedent in this case on them anywhere. Several of them had different handwritings. One of the writings had a date of 2013. There was no way to tell whose handwriting these writings belonged to within this book bag. There was no time for the defense to attempt to get a handwriting exemplar, expert, or anything of that nature to establish who these writings could have been from. And because there was no evidence to prove that any of these writings were from the victim in this case, and also because of there being several different handwritings and several different types of dates and all different types of things within the book bag, none of which can be attributed to the victim in this case, that none of it should be admissible. We made that argument before the court, and that is still our position today. Thank you, Your Honor.
did rule that they would not be investigated. Number one, it's my understanding nobody could definitively say that these were written by Mr. Chapman. And based on that, I deny it. Okay. What's next? For example, on these two that are presented to the court, there's no name on it. Well, his name is not on it. Next, what's your next?
Judge, if I may just add briefly as it relates to those writings. As I indicated earlier, these were writings that were included in the backpack that was on Mr. Chapman's back. The writings are similar in nature to what was included, other items that were included in the backpack. The writings were similar. There were not names, but I believe there were initials on some of the items. And further, Judge, I'll withdraw that. I believe the wallet was found in his pocket, but all of the writings were similar. They were all together in this backpack that was on Mr. Chapman's back, and our position would have been, and the evidence we intended to introduce at trial would have shown that they were all similar in nature.
You don't need to get up and indicate nobody could definitively say that these writings were made by Mr. Chapman. What's your next?
That's all, Your Honor.
Now, you did have some instructions, you can put those on out in the jury trial, okay?
Yes, Your Honor.
And you also have some of other.
Yes, Your Honor.
Okay.
All rise. Be seated, please.